Hi, Michael Kushner here, and welcome back to HOA Hell. With me is Sam Kill, Senior Associate at MBK Chapman. Sam.
Hello, Mike. Great to be with you.
Good to have you. Today, Sam, we're going to talk about, remember a few weeks ago when we did a podcast on one of the most underused and powerful weapons at a homeowner's disposal? We're going to talk about another one today.
The recall.
The recall. A lot of people that live in HOAs have no idea what a recall is unless they have corporate experience. And if they look at trying to recall the governor because that was, an attempt that was made a few years ago, you look how hard that was, they think, oh, it's impossible. Mm-hmm. It's actually it's a lot easier than you might think, and it is a very effective weapon against a board that is not following the rules. In other words, if you want to hold your board accountable and they're not doing what they're supposed to be doing, a recall is an extremely viable avenue. So today we're going to cover all aspects of the recall and the recall petition in California. We're going to go through how recall petitions work under California law, how many signatures you need to kick off the mandatory recall election that the board has to set, okay? What the petition has to say, okay? What are the minimum requirements in order for the petition to be valid itself, how the election is supposed to work, and what happens if your board refuses to cooperate at any point along that timeline. Those are the things we're going to talk about today. And this is a crucial detail that most homeowners don't know about. And I hope today, after listening to today's episode, that you guys are armed with a really quite powerful weapon, which used in conjunction with 5200 really does help shift the balance of power that we discussed in another podcast when we talked about those 7 reasons why HOAs had unequal balance of power, had more power than we homeowners do. Mm-hmm. So let's talk about the power of a recall petition, okay? California law gives us homeowners that live in HOAs the power to remove board members, okay? And it doesn't take nearly as much as you might think to get started. So, Sam, very basic question. Mm-hmm. What is that threshold magic number?
That reasonable low threshold under the Davis-Sterling Act and the Civil Code is 5% of the membership
5%.
To initiate the recall petition.
Okay, so 5% of the membership. So for those of you who are math challenged like me, if your HOA has 100 members, 5 signatures is all you need on a petition to trigger that entire election. And if you heard our episode on elections, you know that there's that 4-month process, and then the 120 days and the 90 days. You trigger it all with 5 signatures. If you have 300, okay, 15. That's not a lot because that's 14 plus you, okay? Mm-hmm. Or in the case of the 100, that's 4 plus you. It's not a hard threshold. 5%, not hard to meet, okay? If you can't muster 5%, then it can't be as bad as what you're thinking. Or you haven't done a good job communicating to your fellow homeowners, which is something we're going to talk about. As a means of helping establish that necessary number, we're going to talk about getting involved with your homeowners and how to do that. But 5%, that's it. That is a remarkably low threshold, and it's so doable.
It really is, yeah.
And so let's talk about it. Once you meet that threshold, okay, assuming that your petition is properly worded, and it's very simple, we're going to go cover that, but assuming your petition is properly worded, and it contains the necessary 5%, so let's say your HOA is 100, you've got 5 names on there, and addresses, and they have to be original. We'll talk about original signatures, okay? And I recommend blue ink. We'll talk about that. But as soon as you have that, you kick off this process. It's a done deal at that point, okay? Yes, there are HOAs can, if you're an abusive recall, if you're a serial recall, there are steps the HOA can take, but that takes a lot. That's a high threshold, so we're not going to even cover that today, okay? So, under 5100, okay, election to remove directors, just like election to appoint directors, has to be done by secret ballot, okay? So, they don't get to know how everybody votes. The board is never going to know how, when that election finally occurs, how everybody voted, who voted to remove them and who voted not to. Nobody's ever going to know, okay? But the petition process is governed not only by the Davis-Sterling Act, but by the Corporations Code. Because remember, in most cases, your HOA is a corporation. So 7510 and 7511 are the statutes that are kind of involved. So let's talk about what the petition has to include, okay? And we're going to talk, we're going to talk later about, you can remove let's say your board has 5 directors. You can remove 1 director or just 2 or just 3 or just 4, or the whole board. Yeah. We're going to talk about why in most situations in California, removing the entire board is infinitely easier than removing 1, 2, 3, or just 4. So you almost always want to go for the entire board. Even ones you support, you can always campaign for them to have them reelected at the election. But it's so much easier in most cases. We'll talk about that later. But you have to have the names of the directors you want to remove. If it's the whole board.
If it's the whole board, it's the entire board. The undersigned will actually request that. If it's select directors, you identify them.
Name them.
So they're ascertained.
Okay. You got to have a clear statement on the petition.
Right.
What the purpose of this petition is to demand a special election to, in this case, let's say it's the whole board, to recall the entire board and elect 5 new directors in place, or to elect 5 directors in their place.
Right.
Now, it can be the same. If all 5 get elected again, then that's that. You shot your wad, right? At least for that purpose, all right? You got to, for anybody that signs the petition, you got to print their name, you got to have their address, and they have to sign. And it's got to be, I recommend blue ink because it's much easier to identify blue ink as original than black ink, which can sometimes look like it's a copy. So you can copy the petition all day long, but the signatures have to be original.
Right.
Okay?
And we'll get to this shortly.
We'll get to that shortly, right. So here's the critical detail. You can target specific board members, but we recommend against it, and here's why. By default, 99% of HOAs in California, at least from my experience, have as their default in the bylaws, typically, something called cumulative voting. Yeah. I even have a short podcast on cumulative voting and the power using cumulative voting to your advantage in an election. Well, if your HOA is one of the most that has cumulative voting, if you go after or target anything less than the entire board, then you have to, under cumulative voting standards, in order to remove them, you have to hit those numbers as if people are voting. And I don't want to go into the details of cumulative voting. I did that in that other one. Yeah. It's complicated. I don't want to do it here, otherwise we'll be here for an hour. But let's just say cumulative voting makes it much harder. It raises that threshold ability, because people can accumulate their votes on one member. So it's assumed that people might do that, so you have to match. In order to remove them, you've got to hit a higher threshold. But if you say the whole board, whatever it is, 5 members, 7 members, whatever it is, we want to remove the whole board, there's no cumulative voting in effect. It's 1-to-1.
Right.
So it's so much easier to remove the whole board. That's why we recommend doing that, okay? And that petition, in addition to the things we just said, so it has to have the purpose of the petition. This is to set a special election to recall the board and appoint or elect new board members, or elect board members in their place. You don't have to say new because it could be the same people. It has to have, or if you're going under individual direction, you have to name them. But again, we recommend against doing that. You have to have the names and addresses, the printed name, and then the address of every member that signs, plus their signature, all in original ink, recommended blue. And obviously, you can't have your cake and eat it too. So you can't have people, I want to sign, but I want to be anonymous. Yeah, that doesn't work, because then you could just make up anything you want.
And they get disqualified.
Okay? You can't have somebody forget to sign. If there's no signature, if everything else is there, the name, the address, but there's no signature, it's invalid, it won't get counted. You won't hit the threshold. Yeah. Which is why you should always get more if you can, get a few more. But you don't need to. 5, under 100 members, 5 is enough. If you want 8 or 10, or you want to send a message and put 30 down or 20, even better. But you don't have to.
I always prefer a slight cushion in case someone's not on title or some other defect to disqualify.
Yeah, in case one of the people you think's on title turns out they're not. Right. So let's assume that their petition is proper, Sam.
Yeah.
Okay. You have it says the right words. You have the requisite number of people. You have the signatures. It's original. All that. What's the board got to do? Well, under the Corporations Code, once they receive a valid petition, the board has 20 days.
20 days, yep, to set a special
to
meeting.
Notice a membership meeting. Right.
Yeah.
Okay, and that meeting must take place no more than 90 days. Hence, right? Now, so the election itself, Sam, let's talk about the election itself. For the most part, it's got to follow the rules that we discussed in our podcast a few days ago, right?
Correct, yes.
But is there a truncated timeline a bit?
There is, and it also in part follows your governing document. So if your bylaws under the recall and removals provides for a special meeting to hold these votes, then you basically would have 2 things happening at the special meeting once it's set. So that's the 20 days plus 90 days out that we discussed. And then you'll have an initial vote on the removal, If that's successful, then you transition immediately in that same meeting to a vote on the replacement directors.
Which is why the ballot for the special election, for the recall election, usually have both issues addressed.
Exactly.
And you want to make sure that the ballot does.
Absolutely.
He raises an incredibly important point. And we were going to talk about it later, but now's as good a time as any. There's two issues you're addressing in a recall. One is, do you agree that this board should be removed? If the answer is yes, if you have the requisite number of yeses, you can't not have a board. So you have to, at the same time, make sure that it's addressing, okay, who's going to be on the new board? And that means that you have the nomination procedure, all that stuff. Right. Now, those, remember, I think the 120-day rule is not at issue, but the 90 days, that is. Okay?
Exactly. Yep.
So you've got to have the nominations go out. All that stuff has to happen. Yep. Okay? And again, we're assuming no electronic
People will
voting.
campaign and same access to membership lists, et
Right,
cetera.
right. Okay, so you still have to have the double envelope system. You have to have the secret ballots. You have to have the independent inspector or inspectors of election, 1 or 3. We talked about that the other day.
Absolutely.
The notices and nomination timelines all apply. Okay, and that, by the way, is when boards start to go wrong when it comes to recall. Okay, some boards stall. They don't like it. What you're basically saying is, you all suck, and we want you gone. You're not doing your jobs, and you need to be removed. That is not. They're going to take it personally. Yeah. Unless you have allies on the board that know, hey, I know that you're naming us all because of the cumulative voting rules, and so, I know you're going to campaign for me, which many times you do. You really only want to remove 1 or 2. You go for the whole board, but you campaign, let's say it's 2. You campaign for the 3 other spots and say, hey, re-elect these 3, but we need to remove these 2. Okay? So a lot of them take it personally, especially ones that see this as their identity.
Right.
These are the bad ones. Okay? If you need to be on the board in order to feel good about yourself, you shouldn't be on the board.
Not the right temperament, yeah.
That's right. So they'll start questioning needlessly invalid or the validity of signatures, even though, like, they'll actually try. I've seen this. They'll try to pull up another signature from the past, from some other the outer envelope. Like, they'll try to compare signatures and go, that doesn't look like their signature. They can't do that. Okay, they can reach out to the person and say, did you sign this petition, the recall petition? Yeah. The person says yes. That's it. If there's a signature there, even if it doesn't look like his other signatures, that's irrelevant. If it's a printed name, an address, and a signature, they've hit those marks. Too bad, but boards will try. We can't read the name on the signature. Well, you can't read my signature. It doesn't mean it's not my signature. My signature can be a happy face with an X through it. It can be anything I want. That's my signature. So
once that petition goes out and initiates that whole process, there's this desperation by these boards.
That's right.
It's just grabbing and reaching at.
There's no anonymity on the recall. The election procedures. Yeah. Those are secret. The actual vote. Okay, but who signed the petition for the recall? You might get phone call. Did you sign this? Yes, I did. Okay, that's all they can do. They cannot say, well, that's not your signature. Invalid. No, but they will try. That's happened. Some will question the petition wording and say, well, it's not clear on what has to be. You don't have to be clear. All you have to say is, the purpose of this petition is to recall the entire board and, remember the second part, and elect replacements. Right. That's it. You don't have to get specific and write a paragraph. Do it in 1 line, 2 lines if you want, okay? So all those attempts to stand in the way of this expedited recall is illegal.
Obstructionist, yep.
It's obstructionist and illegal. Some boards, and this is sneaky. So I'm going to give you the backup of this. Tell me if you've seen this before, okay?
Yes. No.
Yeah, probably. Okay, but let's see for real. Okay, but you're probably right. So you're probably seeing the future. Okay, let's say for a minute that I initiate a recall petition, and somebody on the board moves. They have to move out. They have to leave before the election. So they resign, and the board appoints a new board. What happens to that recall? Well, under the law, it's not the same board that was sought to be recalled. It cancels the recall. So what you would have to do is just get the same people that signed, have them re-sign it and just reserve it. But it starts the clock over. It starts everything over. Well, have you ever seen a board purposely get one of the people on the board to resign so they can appoint somebody new and have a different board?
I've seen that scenario play out, whether it was by design, purposeful. I mean, I didn't really have insight as to those aspects of it, but I have seen it play out.
Well, I've seen it play out, and I've never seen it be not by design.
It's certainly a curious one.
I've never
the timing
seen
of it.
I've never seen a scenario where somebody moves for their job and they have to move to Chicago, and so they have to leave. I've never seen that because that would be the person's gone. They left. That's valid.
Right.
I've never seen that. What I have seen is suddenly a longtime director just decides to resign and they appoint new ones.
Yeah.
And that because what will that do is it push you back.
Yeah.
It throws the whole thing. You have to start over.
And that's a fantastic point. I mean, a lot of people, their initial inclination is like, well, this person got intimidated. They got fed up with
Even though you didn't name them, it's just the whole board.
Yeah, exactly.
That's also one more reason, maybe not to name somebody specific, is just that. But here's the thing: it does happen once in a while. But if the court ever finds out that was the reason behind it, they're in trouble. It's hard to prove that, but one of the reasons why you name the whole board, in addition to the cumulative voting thing, is it prevents anyone from getting so emotionally disturbed that they feel they have to resign. Because if they do that and the board appoints a new board member, and most bylaws give the board the power to appoint a replacement. If yours don't, it won't matter. But if yours do, and most do, they can appoint the replacement to fill whatever was left on that vacancy.
Yeah.
Then it will start over the process. So you're going to have to go to the same people and go, hey, we're doing an identical recall, just to serve it again. And you have to start over. They can't stop it from eventually happening. Now, if it happens again, now you've got a weapon. Now you've got, okay, I would go forward and demand that the election go forward anyway, because now it's a tool. And if the court will shut that down. So it happens once, good luck proving that it was nefarious, even though we all know it was. But if it happens again, like your second time in a row, I would say, nope, don't cancel this, and we're going to take you to court if you try.
Yeah.
Because 2, that's a little bit, that's a reach. Okay?
Yeah.
So if the petition has the 5% and the information's complete, board has to act. End of story. Okay? Period. So next, let's talk about how the recall election works.
Okay.
Okay? So once the board schedules the recall election, the process mirrors a regular director election with the truncated timeline a bit, but it mirrors it. Okay? So here's what happens. HOA will send out the nomination forms to all the members. Homeowners can nominate themselves or can be nominated by others. I nominate, I've already talked to Bob. I nominate Bob Smith. Or I nominate myself, Michael Kushner. You can do that, okay? And you would want to nominate, if you support, let's say, on our example, we have 5 board members. You want to nominate, really, you renominate the 4, and it's just 1. You might say, I nominate, and then list the 4 you like, and to replace so-and-so, Bob Smith, right? So the HOA sends out the nomination form, basically, and you write in who you want the 5 people to be, okay? After the nominations close, so you go through that process, and they will verify with the nominees, right? And then once the nominees are selected, it'll probably, almost always, but sometimes they resign because they know the writing's on the wall. You'll have the same 5, even the one that you want to remove, they'll nominate themselves. Yeah. And so you'll have several people running, okay? But after all that happens, the ballots are prepared and mailed, and following the secret ballot procedures that we talked about the other day that are in 5105 and 5115 and all the code sections, 5100, we talked about all those, okay? Now, 30 days have to be given for members to vote. So those go out at least 30 days before the actual election day, right? And again, we're assuming no electronic, you guys haven't adopted electronic voting yet because that's pretty new.
All paper, yep.
Okay, so we're assuming paper ballots, okay? Then the meeting gets held, right? The actual election meeting and the inspector elections is actually, or whoever's running the meeting will call for floor nominations. And then when it's time to count the ballots, the actual inspector will get in there and open up the big envelopes and pull out the small sealed envelopes that are secret and count, right? Now, here's something critical, though, when it comes to recalls, okay? And this is what he was talking about before, and I want to be very clear on this. It's so important that the ballots ask the 2 separate questions. If the board tries a game where if you get the ballot and they've got, do you vote to recall the entire board of directors, let's say, okay? Yes, no. And that's it. Then you say invalid, you reissue. Reissue that immediately or I'm taking you to court. It has to have that as a threshold question, yes, no. Then if Director X is recalled, who should replace? Or if this board is recalled, who should replace? And then you have
the nominees,
right? And everybody will vote. Well, I want this person and this person and this person and this person. Let's say it's 4 people or 5 people that are up, right? It's the whole board. They have to check 5 boxes, right? Okay, one each. Okay? That's where you can't accumulate. You can't put them all on one. No, you can't do that. Okay? Now, if the recall passes, but not enough valid votes are cast for replacements, that could be a problem, which is why it's also important. Make sure you get your quorum. Make sure you get your quorum.
Big, yeah.
Okay? If the recall passes, but not enough valid votes are cast for replacements, people don't put boxes by nominees. They circle the yes. You got your quorum. You circle the yes, but they don't select. They select 3,
right,
and not 5. Ugh. If you're like most HOAs, your bylaws allow your board to nominate replacements. Your board can actually nominate. The sitting board, which includes the bad person, can nominate replacements. By the way, when you're going after a bad HOA board, it's usually not just one because they'd always be outnumbered. It's usually 3.
Yeah.
So, which is another reason why we say go for the whole thing.
Right.
Because it's usually 5. In most HOAs, it's 5, and you need to get rid of this majority that's ruining everything. So, anyway, for whatever that's worth. So, you want to make sure that your supporters and you have organized, and you've campaigned, you've sent out emails or letters. Emails are better, but or both to every member of the HOA. Make sure you vote. Make sure you vote for this slate. Make sure you vote for one vote for each of these people. You got to have all 5, in this case, you're going for the whole thing, all 5 covered. Okay? In the case where you're getting rid of 3 of them and you're campaigning for 2 of them, you'll write down those 2 and then these 3 to replace the bad ones. You got to tell people to do that. You've got to get people to do both parts of the ballot. Otherwise, you might recall the whole board, but the board can then replace the replacements. Okay? Now, don't allow your HOA to slip on procedure because the regular HOA rules when it comes to voting, except for the timeline we talked about, still apply. Okay? So, secret ballots still mandatory?
Absolutely.
Yep. Okay. Can a board amend rules less than 90 days before the election? Nope. Can't do that. I submit a ballot. I vote. I send it in to the inspector of elections. I mail it. Can I call the inspector next week and say, I changed my mind, I want to change my vote? Nope, you cannot revoke. Once a ballot is cast, and if you're doing it by mail, it's when you drop it in the mailbox. Okay? Now, if you make a mistake on your ballot and you X the wrong thing, you can call the inspector and says, hey, I messed up my ballot. Can I have a replacement ballot? They can send you that. That's okay, because you haven't voted yet. It's the second you drop it in the box, or if you happen to be one of the people that votes at the night of the election, the second you seal it and put it in the envelope and you hand it to the inspector, now you voted. The second you vote, it's irrevocable. Period, end of story. If you screw up and you forget to sign the inner envelope, you did everything right, but you didn't sign it and you remembered after. Oh, I need it back, I need to sign. Nope, you screwed up. Okay? So, and your vote gets thrown out. So, those rules still apply. Okay? The inspector still has to be independent. Follow those rules, right, Sam? They can't be a member of the board. What are the other rules?
Not related, not from the same household, right?
That's right.
So they can be either from within the association, so long as they're objective, impartial, or a professional, right?
You could have a CPA, you could have a professional company, anybody
attorney.
objective, right? Yeah. They have to be over 18. And let's say the inspector counts all the ballots. How long does the inspector have to announce the results?
15 days.
Same as before, 15 days. If you watched our podcast the other day on all the election rules, we covered this. So those all still apply. Okay? And if the board fudges any of those, manipulates any of those, what happens? If you decide to, what could happen?
You could sue them.
Yeah. To invalidate the vote.
Right.
They can't break the law. Okay? Now, let's talk about signature rules, delivery, and validation procedures. So I mentioned earlier that the petition has to be done correctly. It is so important that every I is dotted and every T is crossed. Okay? So, the 5% threshold applies to total voting power, okay? That means 5% of the total number of members. So if you have 100, it's not 5% of a quorum. It's not 5% of 50-50, right? No, it's 5% of the whole membership. So it's literally a mathematical formula. It's 5% of however many member households there are in your HOA. That's the hard number. And if calculating that 5% gives you a fraction, which it could,
round up,
then you have to round up. You can't round down because then you're slightly less than 5%. Even if you're 0.01% less, it's still less. So you round up. If you're at 4.5%, then you have to go to
5.
You have to go. Yeah. So if that means if it's 23.5 members gives you 5%, you got to go to 24. Okay, you gotta have the threshold. That's not a suggestion. That's a floor. Okay, now there is one caveat to the 5% rule, and now's as good a time as any. It doesn't apply in most cases because unlike the East Coast, California doesn't have nearly as many as East Coast. And that is something called a stock cooperative. If you live in a co-op. So if your co-op is governed by the Davis-Sterling Act, okay, the threshold for a recall is not 5%, it's 10%. But that is only for a stock cooperative, and they're relatively rare. I say relatively compared to East Coast when they're everywhere. Like if you look at the Commonwealth states, like Massachusetts or Pennsylvania, they have tons of them. But here, a lot less common. So it's almost certainly not going to be an issue for you. But if you're one of the few in California that lives in a co-op, it's 10%. So if you have 100 members, you got to get your 10. You can't do it with 5. Okay? Now, only members can sign the petition. Okay?
Right.
Let's say you need 5 members to get your 5%. I sign it, and my wife signs it. Do I have 1 or 2 for purposes of 5%?
1.
I only have 1.
1.
If there are 10 people on title and all 10 people sign it, it's 1.
Yep.
It is 1 vote there's 1 petition member per household. So it doesn't matter how many people are on title, only 1 can represent the household for purposes of the petition to recall. So if you have to hit that 5% and you've got 100 members and you got to hit 5, and you have multiple people from the same household signing, then you better have a lot more than 5.
Yeah.
Because they only count as 1 vote, okay, or for petition purposes, okay? The signatures, I said this, have to be original. I recommend blue ink because blue ink looks more, it's harder to make blue ink look like a fake, right? Black ink can look a lot like a really good copy, but blue ink, you can usually tell that it's blue ink. Yeah. So I recommend it. It's not required. What is required is original. You can take the petition and make as many copies as you want, but to go out and get it signed, like the ones that have the blank lines on it. But when you actually come to putting the names, the one that you submit needs to be the original, which is why, and here's the next one, you deliver it in person or by certified mail return receipt. I recommend in person to the management company or a board member, but I recommend in person, but only if you get something in writing, and I prepare this in advance, very brief, saying, I am accepting or agreeing, I have in front of me a petition with this many names on it, okay? Make sure they're clear about what they're receiving. You don't want them trying to pull a fast one, okay? So what I would do, if it were me, and if you want to see anybody in person, that's fine. Send it certified mail return receipt, but I would also email the petition to the day that you drop it in the box, certified mail, send it to the management company. Let's say you're sending to the management and say, hey, FYI, I just mailed this certified mail. This is the petition I mailed. And now you have a record. Why would you, if you had the requisite signatures, why would you print out something other than that and why would you put blank paper in that envelope?
Fantastic.
You wouldn't do that.
That's the way to do it.
So always email it as well, saying, hey, this just went out via certified mail.
Yep.
Okay? Delivery triggers the deadline. That's a rule. Okay? They can't decide on another date. So if you do it in person, it's that date. If you drop it in the mailbox, it's in this case, it would be, I would say it's the date it's dropped in the mailbox, but even if you want to count it as the day they receive, it's going to take a day or 2, right? Actually, I got to look that up. I'm not sure if it's dropping it in the mailbox or it's 1 or 2 days after that. I'm not sure. I forgot to look at the code on that because I always email these. So that works. And then I send it after, but I always email it, but I send the originals and that doesn't matter. If they don't get originals, I'll tell you we never got the originals.
Right.
Okay. Associations have the right to verify signatures. They do, but we talked about that earlier. Yeah. That doesn't mean they can go, well, this doesn't look like your signature. No, the remedy, if they're not sure, is to contact that person and say, did you sign this petition?
Yep.
If the person says yes, it doesn't matter if his signature says Andy Rooney and his name is Bob Smith. Doesn't matter. Okay? And unlike, last one, unlike once you cast your vote, it's irrevocable. If between the time you submit the petition and the time the ballots go out, somebody changes their mind on the petition, they can actually withdraw their signature. Okay? But once the board has acted and set the meeting, once the board has done something to further this election, I think I said a second ago the ballots go out, but that's wrong. I'm sorry. It's once they've acted, once they've received it and they've set the date or they've done that first deadline, then it's too late. But anytime before that, you can revoke. Which is another reason why Sam wisely suggested that if you still need 5 signatures out of the 100, get 8, get 9, get 10, just in case a few people don't tell you when they withdraw. They didn't want to say no to you. They were nervous, but then they went and they canceled it. And then all of a sudden you'll find out you didn't have a requisite number. So always do more, okay? So, Sam, when should members consider a recall as a concept?
Generally, recall or a removal of an entire board is a good option to go to when the issues have become too numerous. All right, the numerosity of issues. You have issues with management, with, let's say, legal counsel. The board is not attending to its fiduciary duties. You've made a number of demands on them. Those have been futile, to no avail.
Or they're doing things that hurt the community,
Right.
and it's more than one thing.
It's not an innocent, oversight or an omission, or they're new on the board. Let's say these are lay people, volunteers.
Right.
It's abundantly clear that it's pretty much a hopeless, irredeemable scenario.
Yeah. So in other words, look, it's not just for when the HOAs are blatantly violating the law. It is a great time to do that, but that's not the only time.
Yeah.
If you have a board they're not listening
Right.
to the members, you and others. Okay, they're ignoring members. They're making decisions without, they're having executive session meetings without issuing agendas or notices, or they're discussing things in executive session that are beyond the things that. If you listen to one of my short podcasts, I went and discussed the things an HOA board is allowed to discuss at executive session. That's it. If they're talking about things you aren't supposed to because they don't want to do it transparently, or you have bullies on the board that are just running roughshod over your rights, that's when you do it. Okay.
Even one quick addition. You may even have, in the best of scenarios, a well-intentioned board but ill-equipped, borderline ineptitude and competence. And guess what?
Or, what about a board that real nice people, but they've turned over all their power to the management company and don't do any supervision. You've now found out this management company unilaterally, does whatever it wants, and the board rubber stamps it. They need to be removed. They shouldn't be sitting on the board.
Improper delegation.
Breach of fiduciary duty, more serious, but anytime. Or if they're making, whenever they're making decisions without transparency, if they're circling wagons and taking the line, we're not going to go and discuss individual, line items with you at this time. You go up to speak in an open board meeting during your 2 or 3 minutes, and you say, look, we want transparency when it comes to this bidding process for this contract that's going to handle these common area fixes. And we're not going to discuss line items. You are going to discuss it. Put it on the agenda and discuss it. If they refuse to put something on the agenda when you make a request to have it discussed in open meeting, then you've got a transparency problem. That's the time you want to remove a board, okay? So a recall is not a temper tantrum, folks. It is a powerful and useful tool to make sure the board understands at all times you are replaceable, you are accountable, because they are, okay? And with the 5% trigger being that trigger, it is a doable and absolutely powerful mode of holding your HOA accountable. And by the way, it is the threat of a recall is often enough to get people to be serious, because even if a lay board isn't familiar with recalls and they go and they turn to the lawyer and go, hey, we just got this letter or an email from a homeowner saying that if we don't start being transparent, or, here, read this, we just got this. And the letter says, you guys are not being transparent. If this doesn't change immediately, if you don't put this on the next agenda to discuss at open meeting, I've already got the number of votes I need to recall you. We're going to just initiate the recall. Can they do that? And the lawyer, theoretically, if they're following the law, will go, yes, they only need 5%. Maybe the HOA goes, ooh, okay, fine, maybe we should. Bad HOAs won't do that. They'll circle the wagons, and they'll count on the fact that they can play shenanigans. They'll count on the fact that most people don't know all the election rules, and they'll count on the fact that they can defeat this, which is why you want to maximize chances, which is why you want to always go for the whole board, not individuals, and we already talked about all that. Bottom line, folks, is this thing. If you're only going to remember 3 things for this podcast today, these are the 3 I want you to remember. If just it's 3, it's number 1, you don't need 5% of the membership to trigger a recall. 2, cumulative voting makes partial recalls harder, so always go for the whole board. That's 2. And 3, if the board resists, The courts can step in and force the issue for you. They don't get to resist. They don't get to do it their way. They don't get to modify the rules inappropriately. They have to do everything within the confines of the law. If they try to play games with the recall by not setting the recall in the proper timeline or fiddling around with the nominations or any of the stuff we talked about today, you can go to the court on a summary procedure and shut it down. You can also go to small claims, okay? Bottom line, if your board stands in your way, push them out of the way. And if you can't do it yourself, you can always come to MBK Chapman, and we'll help you set that board straight, and we'll hold them accountable. If you like this episode, please hit the like button. If you haven't already subscribed, please do so. If you have any comments, we'd love to hear from you as always. And until next time, have a wonderful day.